we have to literally understand what has to be the actual definition of the term arbitration. Many would say that arbitration is just a process which is happening outside the court to settle the dispute. That is the general understanding of everyone, each and every one, including me, when I started this venture into arbitration. But it is not like that. It is actually not a settlement of dispute. It is obviously the adjudication of disputes. For an disputes to be adjudicated, there are various options given. One option, available option predominantly in every case, the civil court system. The courts are there. The courts are the only place where the disputes are resolved effectively, whether it is going to be the commercial disputes or civil disputes or any criminal disputes or even the disputes involving the sovereign state. Not even the option, what's given, that is the civil court system, we do have some options outside. Earlier it was called as non-state judicial system, NSJS. What we are all seeing into this particular arbitration is a well-structured, which has legal support. But there is another system called NSJS, non-state judicial system, which is not recognized by the state or not recognized by the judiciary. It is a system which is informally organized, structured, and delivered by the community itself. There are various communities. For example, fishing community in we are living near the Pulicat Lake, one of the largest lake in the South Asian continent. It is very simple that if you go to that place, we can see the fishermen community have their own structure of resolving the dispute. They don't go to the courts, they don't go to arbitrators, they don't go to mediators, they don't go to conciliators, they don't even go to the local adalat systems. They have their own system how to resolve the dispute. That type of system is colloquially what is called there is Padu system. Padu system is used commonly in the Pulicat fisherman community. Likewise, we have various NSJS which were in practice in various jurisdictions. Coming to the formal acceptance of arbitration, the first option what we can see is that a negotiation. Out of the ADR mechanisms, we have the first one is the negotiation. If a dispute comes, instead of just depending the assistance of a third person, whether it's a court or the arbitration or a mediation, the parties themselves can try to resolve the dispute. Okay, fine. If it is working, it is called a negotiation. If it is not working, then this dispute has to be taken to the next level. The next level of dispute resolution or the dispute mechanism is a mediation, wherein a third party is going to come and he is going to facilitate the dispute. Even if that process fails, then we can go to arbitration. This is how the hierarchy of dispute resolution is acceptable in the present commercial world. Coming to the actual presentation, that is the evolution of legislation in arbitration. The first actual legislation or actual arbitrator who can be considered in this universe is King Solomon. I think many of you would be knowing this. He is considered to be the first arbitrator who settles a dispute between two women who are each claiming on a particular baby. Two women trying to just claim right on a particular baby. King Solomon sat as an arbitrator and tried to resolve. This is an informal way, but still that informal way was considered to be the arbitration which is first evolved. Then we had King Philip. Then we had the 5 Spartan judges. Likewise, various regions, various civilizations had the concept of arbitration. They didn't use the word arbitration, but still they were acting as arbitrators. Now coming to the arbitration background or the legislation background in our country. In Hindu law, one of the earliest known treatise that mentions about arbitration was one of the Upanishad. That Upanishad was actually called Bradra Nayaka Upanishad. That was the Upanishad which used arbitration in ancient law. In that particular Upanishad, there were three types of popular courts. One is called the puja, the local courts. Next was called the Srinis, the person who engaged in any business. And third was kulas, who were members concerned in the social matters of a particular community. Puja, Srinis, and kulas were the typical types of courts which were in usage or practice in the ancient society of India. These three bodies were typically commonly known as panchayat, wherein the members of the same, where the panchayats, then the arbitrators used to deal with the dispute under the system, we now refer it to as arbitration. This is how a small evolution of arbitration came into existence in our country. Next. When it comes to legislation, the evolution of arbitration law in our country, I have just tried to categorize certain periods, which out of my research I got it. It is actual starting from 1772, then 1780 and 1781, all were considered to be the Bengal regulations, which are considered to be mode of settlement of disputes. These were all created for the East India Company. And then certain acts like 1787 Cornwallis Regulation Act, 1860 Madras Regulation Act, 1827 Bombay Regulation Act, then the 1927 Enforcement of Award under Geneva Convention. Next, the 1940 Arbitration Act. All these were British period. Starting from 1772 till 1940, we had wonderful piece of arbitration legislation, but incorporated in various legislations, regulations, as well as the acts, what we had in the British era. All these regulations and acts were dealing arbitration only to deal commercial disputes. Very interestingly, these legislations were dealing with disputes wherein the arbitrators were a domain expertise. It is not a person with legal knowledge. It is not a person who was a judge or a sitting judge or a former judge. It was not a person with a qualification of a lawyer. It is all the disputes were all resolved by persons who are a domain expert. One example I wanted to highlight in this situation. There were cotton association. I think many people would know about that. India was the hub for production of cotton, and a various region of India where the soil was fertile for producing the cotton. All these cotton were procured by the East India Company, and it was moved to England, and in England it was processed, and ultimately the finished product came into India and various the Commonwealth countries wherein the market was there for the East India Company. It was sold to those regions. The particular cotton which is being produced in a particular region has certain quality. Based on the qualities, it was procured and it went to England, and the final product was supplied. If any issue arises out of this quality, procured cotton quality, those disputes have to be resolved. For those disputes to be resolved, they started the arbitration process, and for that, the first arbitration body, which was actually very active in Bombay, the erstwhile Bombay, was the East India Cotton Association. The East India Cotton Association, considering all these regulations and the acts which were there in the British India before 1857, actually when the Queen, before the Queen took over, the Cotton Association, East India Cotton Association, appointed their own members who are domain expert in analyzing the quality of that particular cotton. They were also traders, but they were considered to be a neutral person having the domain expertise, and they sat as arbitrator and resolved the dispute. This is the actual historical background during the British era. But highly appreciable, the consolidated arbitration legislation was the 1940 Arbitration Act. an excellent piece of legislation which was created by British India seven years back before the independence, and this is the base for the present legislation what we are having, that is the Arbitration Conciliation Act 1996. Further down the line, to just help this 1940 Act, there are some conventions, some legislations which were added by the post-independence India, wherein the 1948 New York Convention, India signed in the year ratified in the year 1960. Then the 1961 Foreign Awards Regulations and Enforcement Act was combined. Then the unsettled model law was considered, and ultimately the masterpiece legislation, that is the Arbitration Conciliation Act 1996, was created with subsequent amendment in 15 and 19, what we are presently using. Having looked on the 1940 Arbitration Act, a small historical background and ingredients we can just discuss here. It was actually enacted in the year 1940. Particular date was 1st July 1940. And interestingly, this 1940 Act came in as expansion of the arbitration provisions which were there in the Code of Civil Procedure Code 1908. The Code of Procedure Code before this 1940 Act had some arbitration provisions. Those arbitration provisions which were there incorporated inside the Code of Civil Procedure were brought out, and the entire Arbitration Act 1940 was created. The very nuances of this 1940 Act was that every stage of the arbitration, the court would help the arbitration process. That was the interesting component of it. The court assisted in every stage of the arbitration process. Secondly, the courts had fullest authority to clarify every issues arising out of the implementation of this 1940 Act. Thirdly, very interestingly, the award, the final decision of the arbitration process, those awards have to be ratified by the courts, then only those awards would be enforced. These are some basic interesting component of it. And if you just ask some senior practitioners who are just well versed in the 1940 Act, a very simple understanding of the arbitration clause itself shows that the arbitrator's name would be disclosed. Presently, when we just look into the arbitration clause or an arbitration agreement, we don't have the names disclosed. We do have only a designation, or we have an institution, or we mention about an act which is going to deal with the appointment of an arbitrator or the qualification of an arbitrator or mentioning of an arbitrator who has to be appointed. But according to the 1940 Act, a person, an individual can be mentioned and as an arbitrator, and that arbitrator has to be appointed in the arbitral process. So many interesting components which were there in the Civil Procedure Code under the arbitration categories were brought in the 1940 Act. It was just a facilitating mechanism during the date to just minimize the burden of the court, just to minimize and support the courts. But there are many criticisms when we come to referring to disputes post-award. There is two options are given: application for setting aside of an arbitral award, and there were an option to nullify awards. When it comes to recognition or authentication by the court can also nullify. One option is to set aside the award. Another option was to nullify the award. This created a lot of confusions and anomaly in the enforcement of the arbitration as such. Because arbitration presently, what we are seeing, has to be independent, it has to be confidential, it has to be private, it has to be party driven, it has to be cost effective, it has to be expeditious, and it has to be enforced. So much of nuances are there when we technically understand the term arbitration. That was not visible in the 1940 Act. The 1940 Act is considered to be a starting point for acceptance of arbitration in our country. The acceptance before 1940 was not there. It was only specifically concerned with trading community, and that too in specific trade, that too sector specific. The acceptance rate started when the 1940 Act was there. The people started understanding that, oh, this is a good mechanism, an effective mechanism to resolve the dispute in a reasonable time and with independent person outside the courts. That is how the 1940 Act was considered. Later, when it comes to actual acceptance or arbitration, we have to go into the 1985 Unsettled Model Law. Can you change the slide? Fine. What is this? We have the 1940 Arbitration Act. Subsequently, there was a convention, that is 1958 New York Convention, which is technically called the Convention for Enforcement of Foreign Arbitral Awards. Then we had the 1961 Enforcement Award Act. All these were splitted. Now, the 1985, during 1985, one of the specialized agency of UN, that is the United Nations Commission on International Trade Law, UNCITRAL or UNCITRAL, that body had a working group, that is working group number 2, which was doing a lot of activities on international arbitration, facilitating the resolution of disputes in commercial arena. This specialized agency in the year 1985 structured a model law for international commercial arbitration. It is not for domestic, it was for international commercial arbitration. And the very objective of this model law is that all the member states have to adopt or reasonably adopt whatever the provisions given in the model law in their own national arbitration legislation. This was the idea behind this UNCITRAL model law created in the year 1985. India was one among them. In the 1996 adopted this model law. Very simple. Whatever the provisions provided in the 1985 model law is being typically adopted in our country under the Arbitration and Conciliation Act 1996. Before going into the Arbitration and Conciliation 1996, what is interesting about this UNCITRAL model law? I think many would be aware of this model law, but still this model law also has a history. There is an evolution behind it. In the year 1976, the same specialized agency, the UNCITRAL, had an arbitration rules. I think many would be aware of this UNCITRAL Arbitration Rules 1976. That was the evolutionary basic for this 1985 model law. The 1976 UNCITRAL arbitration rules was used by various chambers of commerce, various governments to resolve the disputes between other government or other entity or investors, and the Chamber of Commerce are dealing with members. They were using this arbitration rules for ad hoc international commercial arbitration. This is how there was an evolution before 1985. Once this 1985 model law was created or adopted, then the countries took the 1976 UNCITRAL arbitration rules as well as the model law as a background, and they adopted their acts, their national laws. Coming to India, India in the year 1996 adopted this model law as sections 1 to section 36 of their Arbitration Conciliation Act 1996. This is how the actual present law evolved in our country. Can you move to the next slide? Yeah. This is considered to be the modern regime for arbitration in our country. Arbitration and Conciliation Act 1996. Very smartly, the lawmakers have included conciliation also in the arbitration legislation, which is a rare piece of legislation which we can't see in any other country. India is the only country which has a real legislation legalizing conciliation also along with arbitration. Now, what is going to be the major component of this Arbitration and Conciliation Act 1996? A law for arbitration should answer dispute, should try to answer who are the parties, should try to answer how the parties can take it to a dispute resolution mechanism. Further, the legislation should facilitate how the process should be, and finally how the arbitral tribunal has to conclude, and further post award how it has to be dealt. Normally, these are the components of any law, and when it comes to model law, the model law has started with the basic principles of acceptance, that is, how to proceed with arbitration. They are trying to give an answer. What is arbitration? When arbitration? When not arbitration? How arbitration? And finally, how it is going to be accepted. What is arbitration? A simple understanding, the definition of the term arbitration was given in the model law. Then there was a component when to go to arbitration, that is, they tried to explain about arbitration agreement. Then they started highlighting about how arbitration, first of all, an arbitrator has to be selected or appointed or nominated. Then the arbitral tribunal has to commence the arbitration, conduct the proceedings, hear the parties' submissions, deal with the evidences, witnesses, and then deliver the award. And that award has to be enforced or it has to be challenged. If the parties are not interested, then beyond challenge or at the time of enforcement, how it has to be enforced, that by the courts. All these are simple nuances or conditions incorporated inside the arbitration acts. But what might be interesting when we look into this arbitration law, the very interesting component, what you have to understand in the arbitration law is the arbitration agreement. What is an arbitration agreement or an arbitration clause? Many would try to say that, oh, it is a separate piece of document goes along with the contracts. It's not like that. It can be separate or it can be part and parcel of a contract. We have a big contract. It can run even to thousands of pages. But to take the matter to arbitration, we need to just have a small arbitration clause incorporated in it, or a small agreement forming annexure to this arbitration or to the contract. This is how we can just put or start with arbitration. But very interestingly, this Arbitration Conciliation Act has given the answer for what disputes we can take it to arbitration. A legislation should answer, and this legislation is clearly answering what has to be taken to arbitration. In a technical language, we can say that what is arbitrable and what is non-arbitrable. What are disputes which can be taken to arbitration or which cannot be taken to arbitration? First, we can just look into which cannot be taken to arbitration. Can we just take a criminal issue to arbitration? No. Can we take labor disputes to arbitration? No. Can we take to tax disputes to arbitration? No. Can we take personal disputes or disputes arising out of personal laws to arbitration? No. Can we take any disputes which is particular to intellectual property disputes as a whole? No. It's keep on. When you just look into the categories of disputes which cannot be arbitration, it's a huge list. Then comes a question, what can be arbitrable? A simple answer is commercial disputes can be arbitrable. How to just distinguish which can be arbitrable, which cannot be arbitrable? There are three things in mind we have to keep in mind. One, when you're going to deal a dispute which comes under right in rem or right in personam. Second, if a dispute is arise, which law, which legislation is going to deal, and that legislation is substantive and procedural or just substantive. Thirdly, whether that disputes has an arbitration clause or not. First, one category, right in rem or right in personam. Right in rem, that is the right what we have or possess against the entire world. Right in personam is a right which is between two individuals. Here, the later part we can arbitrate. If you are having a right against the entire world, for that right, we can't just invoke an arbitration. It has to be through only the judicial system. Secondly, if you are having a dispute, for example, a dispute dealing with rent control issues, we have a separate legislation which is considered to be both substantive and procedural. If a dispute has been substantive and procedural and a legislation is there to deal with it, then those disputes also we cannot arbitrate. And finally, in the Arbitration Conciliation Act, particularly section, when you are looking into section 2, subsection 2, it is categorically mentioned that if a dispute which is capable of being resolved by another statute which is considered to be a special statute, then this act would not apply. This is how we can just categorize, and this Arbitration and Conciliation Act 1996 clearly mentions and distinguish the position of a dispute which is arbitrable and non-arbitrable. Okay. Having said that, what might be the next issue? How the law is addressing the next issue? The next issue is that we have an arbitration clause. With that arbitration clause, you can just straight away go to arbitration. No. We have to appoint an arbitrator. Looking into the arbitration clause, first of all, we have to find the answer regarding appointing an arbitrator. Two things: number of arbitrator, and second, the qualification of an arbitrator. The number, the law, the Arbitration Conciliation Act says that the number has to be any, but it should not be even numbers. It can be 1, 3, 5, 7, 9, like that. It can go on. But the number should be odd numbers. It should not be even numbers. Secondly, the qualification. What does the law say? The Arbitration Conciliation Act 1996, as a principal act, doesn't prescribe any qualification for a person to be appointed as an arbitrator. It says that any person of any nationality can be appointed as an arbitrator. Very clear. The act is very clear. Anyone can be appointed as an arbitrator, but the only thing is that that person should be neutral, independent, unbiased, and impartial. That is a condition, unwritten conditions in the law. With the numbers clarified and with the appointment process, parties can appoint the arbitrator. And for that, if the parties couldn't agree, the law facilitates that the parties can approach, or one of the party can approach the courts, and the court can also appoint the arbitrator. Okay, now it's set. Arbitrators are appointed. Once the arbitrators are appointed, the law has evolved that a person who is sitting as an arbitrator also has to be tested. To test the qualities, to test the jurisdiction of the arbitrators, provisions are there. The arbitrator's neutrality can be tested, as well as the arbitrator's jurisdiction can be tested. So wonderful legislation. Now the testing part also is over. The law facilitates that. Then the law has evolved further. After this, there is always possibility, or even before, to have a preservation mechanism or a conservatory mechanisms to facilitate the arbitration. That we call the interim measures or conservatory measures, what the parties seek. Normally in courts, there are provisions under the Code of Civil Procedure to deal with attachment before judgment. Similarly, in arbitration, we do have a provision for interim measures or conservatory measures. These measures are being facilitated both by the courts as well as by the arbitrators. The law facilitates. Excellent piece. Further, interim measures are given. Now, beyond that, how to deal with the arbitration. the general law is that, or the principle is that, natural justice. A person or the parties have to be treated equally, and the parties have to be given equal opportunity. This arbitration law also facilitates that. Excellent piece. There is a clear provision under Section 18 of the Arbitration Conciliation Act would clearly mention that equal treatment of parties. That is the only thumb rule given in the arbitration law guiding principle of natural justice. Now this is completed. What does the law says next? How the law has evolved? What is there to facilitate? Now comes the core component of legal practitioners and persons with legal knowledge. We are all trained in civil procedure code, and we are well trained to effectively utilize the evidence principle and the act. That is the Code of Procedure 1908 as well as the Indian Evidence Act 1872. Without that, in courts, the procedures as well as the process couldn't happen. These two marvelous epic legislations need not be followed in arbitration. That is what the Arbitration Conciliation Act facilitates. The arbitrator or the tribunal need not adopt the Code of Civil Procedure Code as well as the Indian Evidence Act. This itself shows that since the process is happening outside the code, a strict principle is laid down in Section 19 that the parties as well as the tribunal is not bound by the procedure laid down in the codes. The code procedures, what the procedures are happening, the codes need not be followed. As well as when it comes to dealing with the dispute or the evidences, we need not follow the Evidence Act. Not only in our country, it is very common. This is a principle suggested by the model law and India has adopted. Having said that, if these two epic legislations are not available under this act, how to deal? If you are going to be appointed as an arbitrator, or if you are being parties appearing before an arbitrator based on this particular arbitration law, how to deal without these two? No issue. An arbitration process should be flexible. The arbitrators have the fullest right, responsibility, as well as the discretion if the parties are not agreeing to lay down the procedure. The arbitrator can complete the arbitration within a day, subject to documents only procedure, or the arbitrator can even have a lengthy procedure subject to agreement of parties, similar to how we are having in the courts or any other process. The arbitrators have full right and responsibility to fix the procedure. So much of flexibility is there. This flexibility, which is given by the Arbitration Conciliation Act, is the major advantage for parties going to arbitration. This makes the arbitration process so effective, efficacious, as well as simple. The process is not complicated. There is no strict principles of civil procedure code to be applicable. That means the arbitrators are the sole authority to decide upon the procedure, and for that the only rider what has been given is the arbitrator should treat the parties equally. Now that is set. Now after that, once the procedures are laid down, the arbitrator should find a place to conduct the arbitration. In courts, it's very simple. The Code of Civil Procedure guides us to approach the court, the civil courts, depending upon the jurisdiction, the pecuniary jurisdiction, all various nuances are there. When it comes to arbitration, where does the arbitrator conduct the arbitration? Can the arbitrator conduct the arbitration in his office, in his residence, or the courts provides a place for the arbitrator to conduct? Options are many. When it comes to a private place, the best place is the arbitrator's residence or office. That shows the neutrality. Next, the courts. Whether the courts provides a place? Yes. Early days, it was not like that. Now the courts provide, but in a different heading, that the court annexed arbitration centers which provide the places for these ad hoc arbitrations to be conducted. In that way, it provides. Further, can the arbitrator conduct the arbitration in either party's place? My simple understanding or my initial cases when I started, there was an offer from one of the parties saying that, sir, I have a good place, well furnished office with all the latest equipment. You can conduct the hearing. I just immediately went, accepted that, and I went there. At the time of hearing, the other party objected to it. Simply objected that you can't just conduct in one of the party's place, because if you proceed and deliver the award, ultimately there might be possibility of bias. And that party objected for me to just have the arbitration hearing physically in one of the other party's place. In that way, we have to avoid one of the parties or either parties office or residence or whatever. They don't depend on the parties when it comes to place or the venue of the arbitration. If the arbitration clause says that we need to have Chennai as the arbitration place, fine. In Chennai, there are various places considered to be neutral. Find those places. It can be an arbitration institution. It can be an independent place. It can be your own place as an arbitrator. It can be a place facilitated by the courts. It can be a place facilitated by various associations, professional bodies, chambers of commerce. Go to those places. Even typically, if you look into the historical background of the legislation, the panchayats normally are done in the venue. It is just the traditional banyan tree. That's how it was happening. Now, it is not like that. They do also have a good place, which is considered to be a common place, a community hall. Like that, we can just go there and conduct the arbitration process. When it comes to place, the law facilitates. The law says that the Arbitration Conciliation Act 1996 says that the parties have the full right to agree and propose. If they are not agreeing, then the arbitral tribunal has to decide the place where to conduct, and in that place, the arbitrator has to find a good venue. This is fine when it comes to domestic. When it comes to international, what does the law says? The law is very simple. It is a similar, the same provision applied for whatever applied for domestic would apply for international. Only thing is that the terminology might be used in a different way. Normally, we'll try to use place when it comes to domestic. When it comes to international, we'll try to use terminology seat, juridical seat. Juridical place or juridical seat is very common when it comes to international arbitrations. Very interestingly, now one point we have to keep into consideration. This evolution of arbitration law in our country facilitated us to have only one law dealing both domestic and international. If you go to some places, there are various hubs for international arbitration like Singapore, Hong Kong, Paris, London, as well as Stockholm. These are very prominent arbitration hub for international arbitrations. If you go to example Singapore, the nearest place, Singapore has two legislation. One legislation deals with domestic arbitration and other deals with international. And if you go to Switzerland, Switzerland is considered to be the perfect neutral seat for international arbitration. In Switzerland, they have a statute for international arbitration, exclusive arbitration statute, which deals only international arbitration. Likewise, various jurisdictions has dual laws, one dealing domestic and another for international. In India, we have only one law, that is the Arbitration Conciliation Act 1996, which deals with both domestic as well as international. It has its own advantages and disadvantages. The advantages is that one part, that is part one of the arbitration legislation, deals with both domestic and international, and we need not distinguish and we need not interpret differently to understand which will apply for the domestic and which will apply for international. That anomalies or discrepancy or ambiguity is literally removed And interestingly, when we get back to the Unsettled Model Law 1985, which was for international commercial arbitration, was literally adopted in our country in 1996, both for domestic and international. That way, it is better comfortable for international as well as adopting the domestic situation. This interestingly facilitates the arbitration in a dual nature. That means Arbitration Conciliation Act 1996 deals with both domestic and international if it is going to happen in India. In India, we can have both domestic and international, but the law would be only one. This 1996 Act would apply for both. It is a well settled principle, and this is a major advantage of arbitration conducted in India, and this is why people started, or parties started, or lawyers started to facilitate or effectively use this legislation to arbitrate. Now the place is there. We got the place. The arbitrator has to take the next step. The next step, the law, how the law has evolved, how the procedure has to be followed. Place is done, then the language. Language also the parties can agree, it has been facilitated. The most interesting or the most trouble creating issue for an arbitrator is cooperation from the parties. In courts, I think many would be happy to take all the matters to the court. The court issues summons, the court directs the parties to appear, the courts takes care, or the court's registry takes care of all the process of assuring the parties' appearance. And if there is a failure, the courts can take drastic step to bring the parties, and even beyond that, the arbitral process, the court process can proceed ex parte. So much of aspects has been dealt in the Civil Procedure Code when it comes to non-cooperation or non-participation of the parties or disputants in the court process. When it comes to arbitration, the arbitrator is a private individual. He is a judge, a private judge appointed by the parties, or he is a creature of a private agreement, and he has been appointed. To what extent he has an authority to ask or direct the parties to appear, participate? The answer has to be simple. It is similar to the court process. There is a provision in this law under section 25 dealing with non-cooperation of the parties. If the parties are not appearing, the parties who have initiated the arbitration not cooperating. Secondly, if the other party who has to attend is smartly avoiding, or thirdly, if the parties or the other party who is totally neglecting the arbitration process, how to deal? The answer under section 25 is very clear. The arbitrator can simply terminate if the party who has incorporated or initiated the arbitration. Secondly, the other party is not participating, then the arbitrator can go with the merits of the documents. And finally, if there is total rejection of this process by one of the party, then the arbitrator has full right to go ex parte and decide in an ex parte manner with the documents what available before that arbitrator or the arbitrate tribunal. So much of advantage is given, and this saves a lot of time in the arbitration process. This is clear. How to manage the parties effectively is very clear. After that, how to proceed? It is very simple. Continue with the way what you feel as an arbitrator and deliver the award. The only thing the arbitration law has missed out, at least the Arbitration Conciliation 1996 has missed out, is interesting thing. They have not given the template of how to draft the award. Now comes a question that any person can be an arbitrator. If any person, assuming that a person who's really neutral, impartial, but has a legal knowledge, he's been appointed as an arbitrator, how he is going to draft the decision or the award? There is no template given. And if that person at least have some legal knowledge, they would have an experience or expertise reading into the judgments, reading various journals, the reporters. He would have gone through various judgments. Based on that, similarly, they can write an award. But a person without any legal knowledge, how to deal, the law is silent. This somewhat facilitate to some extent a new development of arbitration, that a qualified person has to be as an arbitrator. And now, I think later I'll touch upon the 2019 amendment. The 2019 amendment, there is a schedule given wherein they have tried to prescribe qualifications for the arbitrator, as well as the experience for the arbitrator, or a person to be considered as an arbitrator. This is how they have just managed. This law, the actual fundamental law, what we are dealing, 1996, clearly gives all the facilities to deal with the arbitration. Now, I think we can just go into the interesting component of the positive sign as well as negative sign of the 1996, and how the subsequent evolution of the arbitration law has helped out to just remove this anomaly. Can you move to next slide? Yeah. This is a first step. Next slide. This is the first step to deal the anomalies or problems with the 1996 Act. In 2015, there was an ordinance. Later, it was accepted as an act, enacted as an act, and it came into force on 23rd October 2015. Can you move on slide? Okay. Very interestingly, some amendments were brought in to deal with the ill effect of the 1996 Principal Act. What does it say? There is a development in the technology. People have started communicating to various telecommunication mode. One of the example is emails. When it comes to section 7, which is dealing with arbitration agreement, it was saying about an arbitration agreement has to be in writing. It has to be signed by the parties. It can be by way of exchange of letters, telex, telegrams, and any other modes of telecommunication, and goes on. When it comes to exchange of letters, telex, telegrams, and various other components, they have just missed out the other modes of telecommunications. They missed out how to explain what are the other modes of telecommunication. Now, the amendment in the year 2015 brought in the options of emails. Sometimes the emails, the exchange of emails between the parties can also bring in the existence of an arbitration clause. Secondly, the definition of the term codes, there was some issue when it comes to dealing with international arbitrations and domestic arbitrations. And invariably, even for international arbitration, sometimes the subordinate codes were given authority to deal with. And that anomaly was removed in the 2015 amendment. Can you move on to the next slide? Fine. What other things? You can just keep on looking into what the evolution in the 2015 arbitration law. Section 11, I think many would be aware of this particular section, which deals with appointment of arbitrators. If you look on the Principal Act, that is the 1996 Act, Section 11, it says that when it comes to parties approaching the courts for appointment, it was specifically mentioned that for domestic arbitration, the authority was lying with the Chief Justice of the respective High Court, or a person designated, or an institution designated. Similarly, when it comes to international arbitration, it was given to the Chief Justice of India, or a person designated, or an institution. That was the situation. It was just overburden, along with the administrative work of the Chief Justice of relevant High Courts as well as the Chief Justice of India. To remove that, in the 2015 amendment under Section 11, when it comes to appointment of an arbitrator in domestic arbitration, it can be taken to any judge of the high courts, the respective high courts. And when it comes to the international commercial arbitration, it can be taken to any judge of the Supreme Court. In that way, it got relaxed. And further, in section 11, there was a new evolution of institutional arbitration that was facilitated. The power which was given to the Chief Justice or the High Court, any judge of the High Courts for domestic arbitration, can also be delegated to institution, and the matter can be referred to institution by the respective judges, and the institution can appoint the arbitrator. So much of relaxation was brought in 2015, particularly under section 11. Further down the line, there was interesting evolution of law when it comes to granting of interim and conservatory measures, that is interim measures given by the tribunal. Section 17, which was dealing with interim measures granted to be granted by the tribunal, originally was considered to be toothless. Very limited power was given to the arbitral tribunal, and that too there was no enforcement mechanism facilitated under section 17. In 2015, section 17 was given wider scope. The same authority what was given to the courts under section 9 was facilitated to the arbitral tribunal also under section 17. The only difference is that the interim measures can be facilitated only after appointment of that arbitral tribunal. And once the arbitral tribunal is nominated or constituted, that arbitral tribunal has full authority to grant interim measures, which is equivalent to the interim measures which could be given by the courts. It was an excellent expansion of authority given to the arbitral tribunal. Based on that, several arbitral processes have been reasonably safeguarded, and there is a real meaning of power given to the arbitral tribunal in the manner of interim measures till completion of the arbitral process, that is till granting the award. To that level, section 17 was expanded, equivalent to the courts. Very interesting development, evolution of the arbitration law. Further down the line, it might be interesting for parties, but when it comes to the arbitral tribunal, India was the first jurisdiction wherein they tried to bring a timeline for granting award under the law. Section 29A was included in the 2015 amendment, wherein the law suggests that the arbitrator has to complete the arbitration process within 12 months from the date of reference. And that 12 months can be extended to another 6 months subject to both the parties' consent. Beyond that, that is beyond 12 plus 6, 18 months, it is by the discretion or the parties or the arbitral tribunal has to approach the court, and the court alone has an authority to grant extension, but that extension with penalty provision. An arbitrator, if he is not capable to complete an arbitration within 12 months or further 6 months subject to parties' agreement, that is 18 months, the arbitrator can be penalized by way of some charging on his fees, what he has collected or what he is going to be collected. This is the first interesting piece in 2015, which we can't see in any other country arbitration law, a time frame given for an arbitral tribunal. Now in 2019, it has some dilution, but anyway, it is an interesting development wherein because of this, many arbitration are effectively now being concluded within reasonable time, not perfectly with 12 months, at least with 18 months, it has been reasonably concluded. And the actual evolution or the reason for inclusion of section 29A was a very interesting case, that is White Industry versus Union of India or Coal India. In that case, literally Various courts outside a country criticize the arbitration process, the delay in the arbitration process, as well as the process happening in the courts pertaining to arbitration. The delay was criticized, and to just look into and give a serious consideration of the other judiciary as well as the pain the parties are feeling when it comes to arbitration. This was included, and now this time frame is excellently working. Further down the line, this 1 month, 1 year, that is a 12 months, was brought into 6 months by inclusion of Section 29B. If the parties agree along the arbitrator or the arbiter tribunal to have a fast track procedure, then it has to be concluded within 6 months. And interestingly, the arbitrators can also be can receive an incentive if they can complete before 6 months or before 12 months what has been agreed based on Section 29A as well as 29B. Next slide. Here, interestingly, in this slide, I had just mentioned about three aspects. One is the amendment in Section 36, that is the enforcement aspect. Second one, there is an inclusion of cost regime. There is a very interesting evolution. And third one, insertions of 3 schedules. Interestingly, I just avoided one. It has to be 4th, 5th, 6th, and 7th. But 4th, I'll just explain. I won't just go in depth. 5th, 6th, 7th are very interesting. Getting back to Section 36, what is interesting evolution of the law here? Most of the practitioners would be aware that once an award is given, after that there is a 3 months time for the unsuccessful party to challenge. If the unsuccessful party is not challenging within that 3 months, or even sometimes a successful party also has an option to challenge if he's not happy with that arbitration award, then after that 3 months period or further extension of 1 month, 3 plus 1 month, 4 months, then it can be straight away enforced. This is a normal process. Earlier, if there is a challenge within that 3 months or 4 months, if there is a challenge, then the successful party can't take that award and file an execution petition, or they can't go for enforcement. A challenge, just a challenge application itself automatically stop the enforcement, give a stay for that enforcement. That was a practice, that was the procedure laid down in the courts. The enforcement would be stopped if there is a challenge. Now, an inclusion in Section 36 says that a setting aside application or a challenge application has to be made by the unsuccessful party along with the application for stay. And if the court grants stay, then alone the enforcement would be stopped. If the court is not granting stay, then the successful party can enforce that award, barring which there is no restriction, even there is a setting aside application. It's a very interesting, and many parties, they just literally earlier, before this 2015, they literally just challenge every awards, and every awards have to wait for reasonable time until the court disposes of for enforcement. Now it is not automatic. Now the courts, if they grant stay, those matters alone, those awards alone can't be enforced. Other awards, if there is no stay, other awards can be enforced in the execution courts. Very, very interesting, and that too many courts are granting stay with conditional orders. A reasonable amount has to be deposited, that is award, assuming that award amount is 5 crores. The courts are granting stay if based on the parties depositing some 50 lakhs or 75 lakhs. A reasonable amount has to be deposited. In that way, the challenge applications are now being brought down, and the enforcement, the obstacles or impediments in the enforcements are now being cleared. Next, the inclusion of Section 31A, that's a cost regime. This is a British principle which has been a new evolution in our law. Unsuccessful party has to bear the cost. Very simple. The cost regime include only that. Unsuccessful party bears the cost. If a party is going to lose, the party also has to bear the entire cost of the arbitration. Cost is four. One is the arbitrator's fees and expenses. Two is the legal fees and expenses. Three is any other expenses pertaining to any plays, the secretarial assistance, what they are getting. Four, the expenses of witnesses as well as the miscellaneous expenses. All the expenses, fees are all included inside the cost regime, and the unsuccessful party has to bear the cost. Finally, the greater change or the evolution, what you can see is the schedules. Fourth schedule, fifth schedule, sixth and seventh. Fourth schedule is dealing with the fees of the arbitrator. A model fee has been suggested for the arbitral tribunal, which has an upper cap of 30 lakhs. It is just a model fee, and it has now been clarified that it is be applicable mostly for domestic arbitration, not for international arbitration. That is fourth schedule. The interesting one is fifth, sixth, and seventh. An arbitrator, before or at the time of appointment, has to give a declaration based on fifth schedule. He has to declare what are the relationship, what he has with the parties. He has to declare what relationship he has with the parties representative. The arbitrator tribunal also has to give a declaration based on what are the relationship he has with pertaining to the dispute itself. With the parties representative, as well as the dispute, all the things, the relationship has to be declared by the arbitral tribunal. There are 34 items listed in the fifth schedule. Assuming that you are just giving a declaration, and the declaration comes under the first 19. Assuming number might be 17th item. Then literally you will be attracted under 7th schedule. The first 19 items given in 5th schedule is being reproduced in 7th schedule. If you are coming under the first 19, then 7th schedule attracts. And if 7th schedule attracts, then you are prohibited to act as an arbitrator. So much of check and balance and transparency has been brought in these schedules. Whatever declaration you are going to make, if it comes under the 7th schedule, then you are not eligible to continue as an arbitrator, so that subsequently the parties need not make a challenge. And for that, to make a declaration, 6th schedule is included. 6th schedule gives a template, a format of how the declaration has to be given. The format has been categorically given, the availability of the arbitrator, how many cases the arbitrator is dealing, and the arbitrator's declaration pertaining to 5th and 7th schedule. All has been covered. These interesting schedules, also a new creature which we can't see in any other country. The evolution of arbitration laws after the 2015 really made this arbitration process a proper mechanism and acceptable mechanism. An arbitrator also has to be appointed in a clear manner without any impediments. And once he is appointed, he has to be a really neutral, impartial, unbiased, independent person to act. Next slide. Yeah. Now the latest one, I'll just try to sum up with another 2 or 3 minutes for a Q&A session. The latest inclusion is a 2019 amendment. Interestingly, can you move to the next slide? The 2019 amendment is a component of all these. The law has evolved so that in India, institutional arbitration is going to be the future. For that, Arbitration Council of India is going to be created. Then, appointment of arbitrator has to be done based on the experience or expertise or qualification to be prescribed by the Arbitration Council of India. That is the 8th schedule. The time frame, that is a 12 months time frame, is being trying to be relaxed. And to effectively calculate the time frame, completion of written submissions, the pleadings, have to be within a reasonable time, that is a 6 months time is being given. And interestingly, confidentiality in arbitration now is being facilitated by the law itself. We are saying arbitration is private and confidential, but still in the 1996 Principal Act, we didn't have. In 2019, the law has evolved, the legislation has evolved that confidentiality is assured by the law itself. And to add on in this, very interestingly, arbitrators' immunity also has been clarified. Two interesting inclusion. One is section 43A and another is 43B, are an insertion in the 2019 which deals with immunity of an arbitrator as well as confidentiality of the arbitration proceedings. Because arbitration has to be very seriously considered to be a confidential provision, and there is no possibility of third party getting involved. Now, the 2019 amendment has brought in this interesting, even though it has some issues in its negative impact also. Since this 2019 has brought in the Arbitration Council experience, the time limit relaxed, as well as confidentiality, including the immunity of an arbitrator, it also would give a clear pathway for future evolution of the arbitration law and the process. Can you move to the next slide? Next slide. Next slide. These are the things what I highlighted. Next slide. Next slide. Next slide. Yeah. This is the final touch-up evolution of arbitration legislation I wanted to highlight. I just tried to cover the 1940 Act, the basic level, with some ancient history of the evolution of arbitration law. Then I just tried to cover the 1996, the actual law of arbitration, which is in use now, and then the 2015 and 19. But for all these, the following slide, the conventions as well as guidelines or the backbone. The New York Convention, that is the enforcement of foreign arbitral award. Then the Inter-American Convention for the international arbitrations, European Conventions for investment disputes, then the IBA guidelines, the conflict of interest, that is the 5th, 6th and 7th schedule. Then the guidelines of party representation, it's also included in the same schedule. Then the IBA rules of taking of evidences in arbitration. Then the unsettled notes on organizing arbitral proceeding. All these are considered to be soft laws. Along with the basic legislation, the model law and the arbitration constitution 1996, that's a evolution. These are the hidden principles which guides the evolution of arbitration law, not only in India, outside our country also. And in India, we have fortunately adopted various of these conventions as well as the guidelines in our legislation itself. In 2015 and 19, interestingly, all has been included. And with this few words, I just conclude my presentation.